Let's talk about what is guardianship. Guardianship is the removal of someone's rights. As of 2022, by Washington state law, you must explore alternatives to guardianship before granting guardianship over a person. Guardianships can be expensive and time-consuming. They require tons of record keeping and annual reporting. Guardianship invites the courts into the lives of a person with disabilities, their families, and their caregivers for as long as the person is underneath guardianship. Guardianship can make it harder for a person to learn how to make decisions on their own and cannot prevent harm, abuse, or exploitation, despite what people may think.
Families are often told by their school psychologists, their family doctors, teachers, that it's important that they apply for guardianship before their child turns 18. And while we understand it's with good intent, and they think it's to prevent abuse and exploitation from happening, guardianship actually cannot do that. It's important to bust the myth that everyone who has an IDD needs a guardianship. It's restrictive, it removes important rights of the individual, and is often considered an invisible form of institutionalization. It's not to say that guardianship isn't a good alternative for some families, but there are other alternatives that are less restrictive and more empowering to the person with disabilities.
The ARC promotes independence, voice, and choice, empowerment, informed decision-making, and the term nothing about us without us. We believe that the best way to keep people with IDD safe is to educate and regularly communicate with them about safe choices, healthy relationships, and how to recognize and report unsafe situations. So let's talk about some alternatives to guardianship. We're going to talk about just some of the many ways to support people with disabilities to make decisions without taking away their rights through guardianship. Some of them are official supported decision-making agreements, educational representative, power of attorney, joint bank accounts, money management programs, representative payee, informed consent, vulnerable adult protection orders, special needs trusts, able savings plans, advanced medical directives, Medicaid services like Community First Choice, and Home and Community Services. We will only be talking about the ones highlighted on the list today.
The first alternative to guardianship we're going to discuss is an official supported decision-making agreement. In 2020, Washington State passed a law that formalizes supported decision-making as an alternative to guardianship. The law gives adults with disabilities the right to enter into a supported decision-making agreement with another adult of their choice who will provide the person with the support they want. SupportedDecisions.org has this quote. It reads, "Supported decision-making promotes self-determination, control, and autonomy. It fosters independence." What does an official supported decision-making agreement include? It has the name of the adult who will be supported and the persons who will support them, the kind of decisions the adult wants help with, including decisions about where they live, where they work, how they spend their time, or how they manage their health care and finances. It includes the kind of help the adult wants when making a decision, including help with gathering information, understanding options, or communicating their own choices. It can also be shared with doctors, bankers, or salespeople to show the person has the right to make their own decisions. Both the adult with a disability and their supporters must sign an agreement in front of 2 witnesses and/or a notary public. Other alternatives to guardianship, like rep payee to manage Social Security benefits, power of attorney for healthcare and/or financial decisions, can also be used in tandem with this supported decision-making agreement. Your loved one's person-centered planning team may be great to consider when putting together a supported decision-making agreement. The best part is, a supported decision-making agreement can be changed or ended by the person with a disability at any time, unlike a guardianship.
The next alternative we're going to talk about is power of attorney. A power of attorney authorizes an individual to designate others to advocate on his or her behalf, including making medical and financial decisions. Unlike guardianship, which is granted by the authority of a court, or a payeeship, which is authorized by a funding source, a power of attorney is given authority by the individual. An individual can sign a valid power of attorney document if they have the capacity to understand what the document says. A power of attorney cannot override an individual's decisions. The next alternative we're going to talk about is representative payees. What is a representative payee? A payee is an individual or an organization appointed by a government agency, such as Social Security, to receive government benefits on the behalf of an individual who cannot manage his or her own money. When a friend or family member is not able to serve as a representative payee, Social Security looks for a qualified organization to be the representative payee. It is a payee's responsibility to use the benefits to pay for current and foreseeable needs of the beneficiary, such as rent, food, utilities, and medical needs, and properly save any benefits not currently needed. Representative payee agencies must complete an annual representative payee report to prove where benefits have been spent. Certified representative payee agencies must be recertified every year and are audited by Social Security every 3 years. Representative payee agencies receive a copy of all correspondence from Social Security and can assist with annual eligibility reviews for DSHS, Social Security, housing, etc. And representative payees are your direct Social Security liaison. Sometimes this is an easier alternative for families.
Our next alternative is Vulnerable Adult Protection Orders, also known as VAPO. A Vulnerable Adult Protection Order can help a person who has been victimized by abandonment, abuse, neglect, or financial exploitation, or threats of such harm. You can ask the court for a Vulnerable Adult Protection Order even when the individual being harmed is unable or unwilling to seek help. Other protection orders may apply, even if they aren't a vulnerable adult. The court will decide if a temporary order is merited and if there's enough evidence to set a hearing for a permanent order. If granted, it can remove or exclude someone from coming near the residence, order them not to contact the individual, or just order them to stop the harmful behavior. Violating a Vulnerable Adult Protection Order will result in a criminal charge if knowingly violated and reported to law enforcement.
Next, we're going to talk about special needs trusts and ABLE savings plans. Individuals who work and receive Medicaid, supplemental Social Security income, and other public benefits may find it difficult to save money and still maintain their benefits due to state resource limits. Let's look at special needs trusts. Funds in these accounts may be used for any expense the trustee deems appropriate. However, if these funds are spent on food and housing, this may jeopardize the beneficiary's ability to collect SSI and other government benefits. There's no age restriction regarding diagnosis of the disability, but must be set up prior to the beneficiary turning 65. Special needs trusts can be costly to set up and maintain. Now let's talk about ABLE accounts. ABLE savings plans are tax-advantaged savings accounts for individuals with disabilities who have an onset of their disability prior to the age of 26. Beneficiaries of these accounts are the account owner, and they can save up to $100,000 without adversely affecting their eligibility for SSI and Medicaid. Funds in these accounts can be used for qualified expenses such as assistive technology, housing, living expenses, education, transportation, and more. These accounts are free to set up, easy to manage, and have very low monthly service fees. Both of these accounts help individuals save towards anything that improves their health, independence, quality of life, and protects Medicaid and SSI benefits from resource limits. Individuals can make direct contributions and can also make payroll contributions. Friends and family members can contribute to these accounts depending on how the trust is set up. If an individual is unable to open and manage an account on their own, they may designate a person or agency to help them. The ABLE National Resource Center has a fantastic comparison tool that can help you figure out which of these options is best for you and your family. Visit www.ablenrc.org for more information. Let's discuss Social Security, why you should apply, and the types of benefits offered, and how to get started. Social Security benefits provide individuals and family members with a safety net for when a worker retires, dies, or acquires a qualifying disability. Benefits can help alleviate some of the more challenging financial needs that families with children with IDD face. The modest income that Social Security provides doesn't solve every problem, but reduces the struggles and helps provide the highly individualized supports that our children may need. If eligible for Social Security benefits, an individual may also be eligible for Medicare and be automatically eligible for Washington State Medicaid. Social Security benefits can play a vital role in helping people with disabilities live independently in the community and meet their basic needs. Benefits give your young adult children income of their own, allowing them to learn to budget and use their discretional funds on things they want. If your child receives paid services from DDA, they may require that you apply for Social Security for your child. Supplemental Social Security income, or SSI, provides monthly payments to adults and children with a disability or blindness who have income and resources below specific financial limits. In most states, SSI automatically qualifies an individual for Medicaid upon receipt of SSI. Social Security Disability Insurance, or SSDI, provides income to those who are unable to work due to a disability and have qualifying work history. Children and adult children with qualifying disabilities may qualify for SSDI if one of their parents is receiving SSDI or has passed away and had qualifying work history. The Social Security Administration has a tool for first-time applicants that can help you screen for what benefits you may be eligible for. For more information, visit the website on the screen If you have any questions, you can reach out to advocacy@arc-spokane.org.